I have a wonderful PowerPoint, actually not. I do have a PowerPoint. It's not wonderful, but anyone who'd like to have it, it will have much more detail on what I'm about to say, can just email me, and I'll be happy to get that for you. I want to begin on behalf of the panel to thank Professor Andy Bibby and the fellows and everyone else who's made our experience here thus far so wonderful. So thank you. I also noted, I think that I want to take the opportunity to thank Professor Rick Griffin for the wonderful job that he has done historically with this center and sort of the inspiration, one of the founding parents, if you will, of it. I believe with Akhil Amar, Professor Amar, that we need to make things accessible. I was 222 pages, or I am 220 pages into a biography of Madison, different than the other biographies. It's entitled Conscience, The Life and Times of James and Dolly Madison. And I have 220 rich pages that would appeal wonderfully to scholars, and this thought comes into my mind very powerfully, and it says, make it accessible. So I'm going to try and take material that's supported in a scholarly manner and make it accessible. And the best way I know of doing that is to start with a story. This is not truly a story, as I used to tell the scouts when I would be around a fire. I would say, this is truly a story, and they would think something of those words that was wrong, but this is in fact a story. This is not that is true. I am in Poland. This is the early 90s. I have the blessing of being able to do what Professor Amar was saying, as a scholar, talk with the drafts people, the people involved in drafting the new Polish Constitution. And they wanted, as Professor Amar said, to learn from our example. So I am now sitting at a luncheon. We have been speaking about, of all things, equality. And I'm sitting at a luncheon. And I am sitting next to Anna Sochocka, who is the James Madison of the Polish Constitution. She's the major draftsperson. Across the table is my friend Leszek Garlicki, who later serves on the Polish Constitutional Court and on the European Court of Human Rights. In front of me is an elegant set of glasses, small glasses, filled with different colors of beverages. They have worked hard in the interest of the common good. They are going to toast the work that they have done. But my friend Leszek Garlicki said, wait a minute. Knowing this was all alcoholic, and I don't imbibe, he said, let us find a way to do exactly what we're trying to do with our Constitution, and that is let Rod toast with us, but not force him to drink. So they handed me a cup of water, and I toasted the great work that they were doing, the public good that they were doing. Now, I'll come back to that story in a minute, because it has everything to do with the difference between Justice Scalia and James Madison on the issue of conscience. Now, first, a little bit about the two of them. I can only tell you a little bit. They were both short. Scalia was 5'7". That's short for our day and age. He was stout, however. James Madison was 5'4" to 6". I think 4 is probably true, but I opt for 5'5" because in the Madisonian manner of dealing with things, I make a compromise. So we're going to say he's 5'5" tall. And they were both affectionately called by nicknames. Justice Scalia was Nino to his friends. James was Jimmy, except to his beautiful wife, Dolly. To Dolly, he was my little Jimmy, because she was 5'8". And she was husky, like Scalia, and Madison was frail as a rail. So, they both, Madison and Scalia, shared a commitment to principle, especially to constitutional principles as they saw them. They both also were friendly, disarming opponents. They discovered if you could just get them in the room with their opponents, it made it very difficult for their opponents, because they also shared a power of intellect. They were also both fiercely patriotic. And they were both considered by many in their day to be leading constitutional theorists. But there were striking differences between Scalia and Madison. Madison was more likely than Scalia to seek consensus. Madison would seek to forge agreement and to use his intellect for that purpose. Scalia was more than willing to stand as a lone dissenter when, in his view, need required it. Madison also, in my view, was the greatest proponent of what he referred to as the sacred right of conscience of any person in our nation's history. That may be important, it may not. As a matter of constitutional interpretation, he was, after all, the father of the Bill of Rights and the father of the First Amendment, so maybe it makes some difference. If for no other reason, we ought to listen to him because he was pretty intelligent. And here's where they differed. Justice Scalia believed in the deferential way. He believed that the people should make determinations, including the public good. And when that came into conflict with religion, unless that public good was directed specifically to harm a religion, then it was too bad for the person of religious conscience. They would need to yield to the public good. That really is what he decided in his opinion, one of his major opinions, one in which he was able to forge a majority in Employment Division of Oregon versus Smith, in which he held as a broad legal principle that a general law, so a general law that's neutral, not specifically intended to deal or single out a particular religious group, was lawful even if it entailed the destruction of an individual's religious belief and conscience. Now, I have in my materials a number of excerpts from his opinion. I don't have time for them. You'll have to trust me, that's what his view was. And it became the majority, and it is the view of the court today. A view that religious belief is protected fully. Religious exercise is not protected if it's a general law that's neutral. He thought that having such a system would create anarchy. So, how about Madison? Madison said this: that religion or the duty which we owe our Creator, and this is in his draft for the Virginia Declaration of Rights, and the manner of discharging it being under the direction of reason and conviction only, not of violence or compulsion, all men are equally entitled to the full and free exercise of it according to the dictates of conscience. Now, essentially what he's saying is that conscience is something between a person and God, and the government is not in a position to intervene, whether it does so through a neutral general law or not. Here's some more on Madison. Madison was fearful, and I have materials in my paper on this. He was fearful of writing a Bill of Rights because he knew language could be used to constrain rights. He said even when the Almighty condescends to put his text before eyes, it can be read in a variety of forms. And he was fearful that this natural right could be limited if it were put into our Bill of Rights. Ultimately, Jefferson persuades him. He does put it into the bill, and in fact, in 2 or 3 different places, he talks about the right of conscience in his proposed Bill of Rights. That he said, first, the civil rights of none shall be abridged on account of religious belief or worship, nor shall any national religion be established, nor shall the full and free rights of conscience be in any manner, nor on any pretext infringed. Then he added, lest that be lost, no state shall infringe the equal rights of conscience, nor the freedom of speech, press, so forth. He clearly, in 1792, in his article on property, this is afterwards, and he's reflecting on the right of conscience, and he says, essentially, conscience is the most sacred of all property. Other property depending on positive law. There's this thing, positive law, out there. The rules passed in a legislature. The exercise of conscience, he said, being a natural and inalienable right, was the one that was most sacred, sacred meaning set apart from government action and intervention. It was to be protected at all costs. When he, after his presidency, at the conclusion of his presidency, in his 8th State of the Union address, he said this, because I haven't had much time to talk about establishment. He said, that he wanted to protect the equal interdict against encroachments and compacts between religion and the state. So what he wanted to do was protect both against religion with Sharia law or in any other way commandeering the state. By the same token, he wanted religion and conscience to be free from the state. An interdiction was an interesting because it had military sorts of connotations, and he'd just been through the War of 1812. This notion of interdicting, of that kind of encroachment, was very much against his belief in this vibrant, sacred right of conscience. That the only time he said it could be limited was when the equal right of conscience of another was infringed, meaning their right of conscience, or the interests of the state were manifestly endangered. So, Scalia, in short, found safety in permitting government to regulate religion, so long as it did so in a manner that furthered the public good and in a neutral way. Madison, on the other hand, found safety in recognizing the sacred right of conscience, a right that was for him largely beyond the reach of government action. And so, that's the difference I highlight in my talk that was much longer, but we want your questions.